But ultimately, it can be fair so long as you thereafter follow the correct process in making that person redundant. And that's that process I'm going to discuss today in today's briefing. So things that are going to be involved with conduct or capability, or SOSR, otherwise known as some other substantial reason, or statutory restriction. We'll touch on them very, very slightly, but today it's going to be redundancy we're concentrating on. Now, as anyone who knows, who's phoned through to the legal and HR team and spoken to me, very often, in fact almost always, I will speak about the statutory definition of redundancy. It's section 139 of the ERA. You always have to come back to that. Ultimately, without reading through what it says there, the statutory definition is where an employer has a reduced need for employees who do a particular type of work. Okay, so therefore, work of a particular kind. So, for example, a company has 10 drivers and the haulage work drops off, so you need fewer drivers, therefore you make 2 of the 10 redundant. So that's because there's a reduced need for employees who do that particular kind of work. Now, there's a process involved in making these people redundant, and that's what I'm going to talk about here just now. So the first thing that you have to do is to put together a business case. Why are you making these people redundant? Again, if you've spoken to me on various HR calls, the main aspect of UK employment law is a company's justification. Why are you making that person redundant? Why are you transferring from that role to that role? Why are you changing their terms and conditions? Why did you allegedly discriminate against them? Why did you make that particular decision? So ultimately, the business case is the company's economic rationale for making people redundant. Now, some of the reasons could well be there's been a loss of contract, there's just a general downturn in the markets, there may be new business practices that are now make things more efficient, you may have automated some of the processes that you have, for example, so you no longer need 3 people to do a particular job, you only need 1 person to man the machine, excuse me, man the machine that now does that job. So that's the business case. Now what you do is you then put that business case to the employees who are at risk, and you then look to them during that process to see if there's any way to mitigate or avoid the need for redundancies. And that's the whole idea of consultation, is you'll offer voluntary redundancy, you look for changing roles or working hours, limiting overtime, pausing recruitment, things like that. All of these are ways, hopefully, that a company can mitigate or avoid the need for redundancy. And the whole idea of consultation is that you put that to the employees to see if they can come up with any ideas. There may well be some things that the company hasn't thought of. Now, very often that's not the case. The company has done a full business rationale and full due diligence on the matter, but you have to be seen to have asked your employees about this during the consultation phase. Let's try and move this slide on. Apologies, my computer has frozen a bit. Sorry, excuse me. Let's go back a wee bit. Right. Apologies for that little IT. So redundancy pools. Invariably, when a company is making redundancies, it's not the entire company that's going to be affected. There may well be specific departments or certain groups within departments who need to be targeted, who need to be highlighted for redundancy. They are known as redundancy pools, and those are the people who are put at risk. You'll maybe have heard me mention things like an at-risk letter. That's what you give to somebody when you're first telling them they're at risk of redundancy, as goes with the title. Now, a company has to think carefully about who is going to be in the pool, because that in itself could be a reason for challenge further on down the line if a aggrieved employee wants to raise an appeal or perhaps even raise an employment tribunal claim against the company. It can't just necessarily be on the job title. The example I often give is if a company is, for example, going to be making its reception staff redundant because there's been a reduction in need for reception work. However, when you scratch the surface of the job titles, the receptionists do a little bit of work with the administrators, and the admin do a little bit of work, and receptionists overlap with finance department. There's a lot of interchangeability between the departments. You have to scratch the surface of the job titles to actually consider the skills of those employees during that particular time. And that comes down to an important point as well. The whole idea of redundancy is it's about the role itself. It's not necessarily, in fact, it's not about the person who is in that role. Very often people will phone me, companies will phone me to say, we've got somebody in the role, they're not very good at it, we can't really be bothered performance managing them, we're just going to make the role redundant. Well, and I go, well, that sounds more like a capability dismissal to me. Talk me through your rationale. Well, we're going to get rid of them, then a couple of months time we're going to rehire somebody in that role. That's not a redundancy, because it's not a reduction for the employer of work, of employees who do a particular type of work. You still need that role, it's just the person who's in that role is not very good. The way an employment tribunal would expect you to deal with that employee is to put them on performance management and then take them through an escalating level of warnings if they don't perform, and eventually dismiss them for capability. The moral of that story is, don't dress up some other type of dismissal into redundancy just because you think it's easier. It's not. It'll actually, in the longer term, put the company in greater legal peril. So, selection criteria. This only kicks in if there is going to be more than one person within the pool. If it's only one person, it's what's known as a standalone redundancy, and you don't need to consider selection criteria. You just need to make sure that there aren't any other people in that particular pool. So selection criteria is when you have a number of people within a pool, but not all of them are going to be made redundant. And in that case, you need to select between them using objective criteria. And you can see the criteria here in red: skills, qualifications, performance, disciplinary, absence history. But be careful of that, because you've got to exclude disability-related absences and certainly anything related to pregnancy, related to sickness as well. Also, we should have put on there any absences related to statutory type leave. So say, for example, time off for dependent leave or parental leave. They should not be added into the selection criteria rationale for that. Now, the whole idea of having objective criteria is it's so that the criteria can be justified if they're ever challenged by the employee themselves at appeal stage, or, as I said earlier on, at an employment tribunal. The whole idea is that an employee should know why they are at the bottom end of the spectrum and being made redundant, whereas people at the top were not made redundant. So they can understand, for example, that on the skills and qualifications, perhaps somebody has a degree, whereas somebody else only has perhaps a HND. Somebody is multi-skilled on 4 or 5 different machines in the machine shop, whereas another person is only skilled on 2 or 3. Therefore, you can understand why that person has a higher score and that person has a lower score. Or somebody is on a written warning for misconduct, that person gets a lower score than somebody who has a clean disciplinary record. So hopefully that all seems quite straightforward as well. What you're trying to avoid is any scoring criteria that are more subjective in nature. So I've seen people companies try to use things like attitude or flexibility. Now, if you can objectively justify why those are in there, then that's fine. If you can give actual specific examples of flexibility or good attitude, then that's fine, but it starts to err more towards subjectivity. And when you start getting into subjectivity, that's when people can start bringing in arguments that the reason why you didn't like me, my attitude, is because I'm black, or the reason why you didn't like my flexibility is because I'm a single mum, which leads into potentially some sort of discrimination argument. So therefore, try and keep it as job orientated and objective as possible as well. Now, it says here minimum of 2 people to conduct the scoring. Ideally, that should be somebody who knows what the employee does. So a line manager or a department head, somebody who is involved. And the way that some companies do it is they will have 2 people scoring the same person, scoring the same employee. They'll then amalgamate the scores. That's absolutely fine and give an average. What other companies do is that they will have 1 person who will do the scoring, and then an overarching person, a moderator, will look at all the scores put together just to make sure that they all appear correct. Because if there are going to be different, for example, line managers doing different people, you would hope that one overarching person can see that there has been consistency. So to go back to the disciplinary example, for example, if one line manager is only given somebody who has got a written warning 0 out of 5, whereas another line manager is given a written warning person 2 out of 5, you can see there's a little bit of a lack of objectivity, a lack of consistency there as well. And at the final bullet point there at the bottom, as part of the consultation as well, The employee should be able to see their own scores, not anybody else's, see their own scores and be able to challenge them. So, for example, somebody says, you've put me down for having 0 out of 5 for having a written warning. That's not the case. My written warning actually lapsed 2 months ago. Oh, that's right. I'll go and check that. And you never know. That might actually be the case as well. So it's an ongoing two-way consultative process. Now, consultation does not mean agreement. It may well be that the employees think that they're bringing forward good ideas for cost cutting, good ideas to mitigate the need for redundancy, but as long as the employer has a justifiable rationale for knocking that back, then you can disagree with them. It's consultation, not agreement. Now, I'm going to touch on two aspects of consultation here as well. Consultation individual and later on consultation collective. You will probably see where I'm going with this as well. The whole idea is you speak with the employees to try and see if they can come up with any ideas to mitigate or avoid the need for redundancy. And that should be a process, not just a one-off meeting. At-risk meeting, you tell them they're at risk and why, i.e. the business case. Then you meet with them again afterwards, after a few days, to tell them what their scores are, but also to see if they have had any ideas in the interim since you gave them that initial at-risk meeting, because it might well come as a shock to them to say that your department is at risk. They're going to be making 3 out of 5 of you redundant. If that was the end of the process, it's been basically placed upon them as a fait accompli. What you need is to give them time to think about it, to then come back with meaningful consultation points as well. And after that second meeting, if there aren't any further points, then you can move to a final dismissal meeting as well. Depending on the circumstances, you can expedite this as well. If the employees are saying, look, Keys, we just want to go. We understand that we've lost a major contract, or we understand that the bottom is falling out the market. Can we just get through this so we can be redundant and go and look for another job? Things like that. On the flip side, however, if the employees are bringing up ideas after ideas after ideas and are challenging various things, then you need to again be seen to have come back with a certain rationale to have answered those points as well. Now, collective consultation, as the name suggests, that's when there are larger redundancies. So 20 or more redundancies on one establishment within 90 days, then you're going to be looking at 30 days. If it's 45 days, if it's going to be 100 or more redundancies, which is a really large redundancy as well. Now, the two main aspects, in fact, the few main aspects of this are, number one, you need to send what's known as a HR1 form to UK government to let them know that there is a collective consultation and redundancy pending. And number two, you have to consult with employee representatives. Now, if you're a trade unionised environment, that should be whoever your trade union reps are, be it Unite, GMB, Unison, whoever. And however, if you don't have your own trade union recognised, then you need to elect your own representatives there as well. And there is a certain process for that, which we can talk you through. Electing representatives, making sure that each individual department is covered, and each individual pool of employees is covered as well. Now, there's no particular magic formula. It's not like one rep has to cover 5 or one rep has to cover 20 employees who are at risk. It just has to be a reasonable amount to make sure that the employees are getting their collective consultation aspects. And what you also have to give those reps is what's known as a Section 188 letter. Now, that's a statutory letter that outlines all of the particular reasons and all of the particular rationale for the redundancy. It says, this is why we're making people redundant. These are the departments that are going to make redundancy in. These are the particular types of employees who are going to be placed at redundancy. And this is the process by which we're going to follow. Now, we have template HR1s. We have template Section 188 letters. So please, if you're going to be going through a redundancy at all, especially if you're going through a collective redundancy, please phone through to legal and HR first, well before you start the process. Because what we don't want is that even if you have a good business rationale for the redundancy, it's for the company to fall down on procedural aspects as well. So please, final bullet point there, take legal advice from us. Now, one of the fundamental aspects of redundancy process is that an employee should be offered any suitable alternative vacancy within the organisation. So say, for example, you're making a machinist on a particular type of machine redundant, but there's a vacancy for a machinist on a different type of machine available. There's an argument, strong argument, that that employee should be offered that particular role as well. Now, the way that I describe it is that suitability is not binary, it's not black and white. There's going to be a bit of a spectrum. There's never going to necessarily going to be a suitable alternative vacancy where you can absolutely slot somebody from that role into that role, from the redundant role into a vacancy. There might well be a degree of retraining needed. There might well be a degree of trial period to make sure that the person fits in there and they like it, or the employer says, no, sorry, you're not a good fit for that. And there are various different aspects of statutory trial periods, which I can talk you through if you ever have that situation as well. Now, the second bullet point there is, how can I describe it? One of the only two aspects of positive discrimination in UK employment law, which is basically anyone who is on maternity leave, parental leave, adoption leave, they get first dibs at any suitable alternative vacancy. So even potentially if there's somebody else who is not in one of those classes of mat leave or paternity leave, if there is somebody slightly better qualified, the person on mat leave still gets that role. As I say, that's one of the only two areas of positive discrimination in UK employment law. The other area of positive discrimination being the area of reasonable adjustments under discrimination law, which is a whole other discussion for another day. Now again, if you do have people on maternity leave who are being made redundant, they have higher protections than normal employees. So again, I would urge you to take legal advice on that particular situation as well. And whilst we're still on the topic of employees who are on maternity leave, parental leave, etc., very often employers find that they can, for want of a better term, do without somebody when they're on extended family type leave. And they just think, right, we can make that person redundant while they're away because we've managed to do without them. There are inherent dangers in that because of what I mentioned a few moments ago. People on these types of leave, invariably ladies on maternity leave, have heightened rights. The reason being is because they have been particularly targeted before by employers, and they are seen as being especially vulnerable in that particular circumstance. So moving on. Redundancy pay. There are a number of different payments that go to employees who are made redundant. Number one, if they have over 2 years service, then they get a statutory redundancy payment. And that is worked out on a number of different factors: age, length of service, and their wage. And you can calculate it via that link there in the redundancy payment calculator. And for want of a better term, the older you are, the longer your service, the higher your wage, the more redundancy pay you get, albeit it is capped on gross weekly wage. So somebody who is very, very highly paid will still not get a redundancy pay which recognises their entire salary, because it is capped at a gross weekly wage figure as well, and that increases every single year. Currently it's £700 odd, that particular amount. Other payments that an employee gets are their notice pay. Now you can either have them work the notice or pay them in lieu of notice, otherwise known as pile-on, plus any accrued annual leave that they get as well. So if they still have 10 days annual leave to take, they should get payment for that as well. Now, many employers offer an enhanced redundancy payment as well, just as part of their contractual terms. Something for you to bear in mind is that if you're going to be making somebody redundant, and certainly if you're going to be paying them enhanced redundancy pay, and certainly if it's going to be a very high enhanced redundancy payment, then it might well be worth considering what's known as a settlement agreement. A settlement agreement, as some of you may know, is a belts and braces approach to make somebody redundant. In fact, to dismiss them entirely. And it's where the employee signs on a dotted line on a legal document after having taken legal advice, but at that point they are signing away their rights to take an employment tribunal claim against the company in future. Now, the quid pro quo for that is that the employer has to pay the employee a heightened sum of money to go. It can't just be you can get your statutory redundancy pay and go. It will have to be a statutory redundancy plus X factor as well. Now, where settlement agreements are often used is where A, there's an enhanced redundancy payment and the company just wants to make sure they're getting their worth for that enhanced redundancy payment, or number two, is where the rationale or the process for the redundancy is not the strongest. Perhaps they're not wanting to go through the full consultation. Perhaps the business case isn't as strong, but for a commercial reason, they want to expedite through the redundancy process, and thereafter just make sure they've got the safety of no employment tribunal claims. So they pay the employee an extra sum of money, but the employee signs on the dotted line for the settlement agreement. Now, that was a whistle-stop tour of redundancy pay and redundancy processes. We have another 8 minutes, and I'm happy to go on beyond that if there are any questions. So, folks, over to yourself. Let's hear from you. If you don't want to speak, I can have a look in the chat as well. Let me just see.
Hi, Kevin. It's Mike from Alstrom.
Mike, hello. How